Good afternoon, everyone. Thank you for joining the webinar. Today, I will share with you the first part of the webinar, and the topic is Overview of Licensing Conditions of Moneylender's License. Before I start, I would like to remind you the restrictions of carrying on moneylender's business under the Moneylender's Ordinance. According to Section 7 of the Moneylender's Ordinance, no person shall carry on moneylender's business without a license, and licensed moneylenders shall only carry on moneylender's business at the premises specified in the license and shall comply with the licensing conditions when conducting moneylender's business. If any moneylender is in serious breach of the licensing conditions, the licensing court may suspend or revoke its license. Now I will start to talk about the licensing conditions one by one. Under the licensing condition 1, before entering into any agreement for loan, the moneylender shall ask the intending borrower to state in writing whether or not he has entered into or signed any agreement with any third party or for or in relation to the procuring, negotiation, obtaining, or application of the loan, guaranteeing or securing the repayment of the loan. This is the so-called third-party agreement. And please note that an agreement with a solicitor instructed by the intending borrower for provision of legal services solely is not a third-party agreement. If the answer is yes, the moneylender shall state in writing in the loan agreement that the name and address of the third party, whether the moneylender is in any way related to the third party, and the nature of such relationship. This should be prepared by the moneylender. In addition, the moneylender shall ask the intending borrower to personally provide a copy of the third-party agreement and attach the third-party agreement to the loan agreement. Annex 1 of the Guidelines on Licensing Conditions of Moneylender's License is a sample form on disclosure of the existence of third party by intending borrower. And Annex 2 of the Guidelines on Licensing Conditions is a sample form on recording the particulars of a appointed third party involved in a loan agreement. Under Licensing Condition 2, unless the third party has been appointed by the moneylender as appointed third party and has confirmed in writing to the moneylender that he has not charged and will not charge any fees, however named, from the intending borrower, and has not otherwise agreed with the intending borrower that the intending borrower pays or will pay any fees, however named, to any other party, whether for the purchase of any goods or services or not. Otherwise, the moneylender shall not grant or agree to grant any loan to the intending borrower. Annex 3 of the Guidelines on Licensing Conditions is a sample form on confirmation by appointed third party on the charging of fees. For Licensing Condition 3, the moneylender shall provide in writing, to the satisfaction of the Commissioner of Police and the Registrar of Moneylenders, the name, address, and identification number of the appointed third party. The third party is not considered as an appointed third party until after the name and address of the appointed third party appear on the register kept by the Registrar of Moneylenders. And the forms on reporting by licensee of particulars of appointed third party can be downloaded from the company's registry website. And the list of third parties appointed by a licensed moneylender in relation to the granting of loans can also be downloaded from the company's registry website. And the particulars of appointed third parties can be searched from the e-services portal of the company's registry. Here are the screen dumps of the e-services portal. And this is the search page. Under Licensing Condition 4, moneylender shall not knowingly allow or permit any person to charge, recover, demand, or receive any fees, however named, from any borrower or intending borrower. Please note that any person includes the moneylender or his partner, employers, employee, principal or agent, or any person acting for him, or any appointed third party. Please note that borrowers shall not be required to purchase goods or services and shall not be charged with processing or administrative fee. And moneylender should check and ensure that there is no fee charging provisions in the third-party agreement attached to the loan agreement. Under licensing condition 5, before entering into any agreement for loan, the moneylender must give explanation to the intending borrowers of all the terms of the agreement, in particular the interest rate expressed as a rate % per annum and the total amount of interest payable, the amounts of repayments, periodically and in total under the agreement, the possible consequences for any default in repayment, including the taking into possession and sale of any security involved, and any overriding right of the moneylender to demand an immediate repayment. Moneylenders must keep written or video or audio records to show that he has complied with the requirements under the licensing condition 5. Annex 6 of the guidelines on licensing conditions is a sample form for recording the explanation of terms of loan agreement given to the intending borrower. And for licensing condition 5, there are a few more points for you to pay attention to. The first one is that moneylenders should clearly explain to the intending borrower all the terms and conditions of the loan agreement, but not merely the crucial parts of the loan agreement. Even where the intending borrower states that there is no need for an explanation, moneylenders should still comply with the requirement to provide an explanation before entering into the loan agreement. Leaving the intending borrower to read and understand for himself the terms of the loan agreement does not fulfill the requirements under this condition. And licensing condition 5 covers all kinds of moneylenders, including moneylenders who establish business relationship with borrowers by a non-face-to-face approach and keep records in video or audio form. For licensing condition 6, the moneylender shall not obtain or collect personal data from any person from another person, or use such personal data obtained or collected from another person for the purpose of or in relation to the moneylender's business, without the written confirmation from that other person that the disclosure or provision of such personal data by that other person for such use of the moneylender is not in contravention of the provisions of the Personal Data Privacy Ordinance, or when the moneylender has knowledge or has reasonable grounds to believe that the disclosure or provision of the personal data by that other person for such use of the moneylender is likely to be in contravention of the provisions of the Personal Data Privacy Ordinance. Moneylender must also keep records to show that he has complied with this requirement and the provisions of the Personal Data Privacy Ordinance. For licensing condition 7, moneylender shall not accept a subsidized flat provided by the Hong Kong Housing Authority as collateral for the loan to the borrower, unless the borrower has produced to the moneylender either a written confirmation from the Hong Kong Housing Authority that the necessary premium for removing the restrictions on the alienation on the said flats has been fully paid, or the written approval of the Director of Housing, granting approval to mortgage or charge the said flat. For licensing condition 8, the Chinese version of any advertisement issued or published by the moneylender for the purpose of the moneylender's business as a moneylender must clearly show the Chinese character 放债人牌照号码 and immediately followed by the number of the moneylender's license. Here is the example. Under licensing condition 9, any advertisement in relation to the money lending business, whether in textual, audio, or visual form, must be fair and reasonable, and not contain misleading information, and contain moneylender's telephone hotline for handling complaints, and a risk warning statement. Here is the risk warning statement. Warning, you have to repay your loans. Don't pay any intermediaries. The risk warning statement must be in the same language as that of the advertisement or relevant parts thereof, and clearly audible in the audio part of the advertisement. In order to ensure that the advertisement is fair and reasonable and does not contain misleading information, the advertisement must not contain information that may mislead or deceive members of the public, must not emphasize any potential benefits of a product or service, without also giving a fair and prominent indication of any relevant risk, must not disguise, omit, diminish, or obscure any relevant fact, which will result in the information or message being insufficient, unclear, unfair, or misleading. Any important information must be in conspicuous text and placed in a conspicuous position in the advertisement. The advertisement should not carry information that understates the cost of borrowing and should not carry information that overstates the ease of borrowing. And a licensee must not in an advertisement state that an unsecured personal loan is available regardless of the borrower's financial circumstances or status. Here are two examples of advertisement which are considered as misleading. The first one is that if an advertisement states that certain loans are interest-free or 0% interest, etc., it will give the impression that there are no interest or monthly fees payable for the loan. If a monthly administrative or handling fee is charged, the advertisement would be misleading. And the second example is a statement or an implication for an unsecured personal loan is guaranteed or pre-approved, or is not subject to any credit checks or other assessment of the borrower's financial position. It would be misleading, as the licensee is obliged to undertake an assessment of the financial status of the intending borrower before entering into an unsecured personal loan agreement pursuant to the licensing condition 15. And there are also some points for you to know for the display or broadcast of the risk warning statement for different types of advertisement. The first type is advertisement in print. The risk warning statement should be displayed in text in at least 50% of the font size and in the same font type and color as the other contents of the advertisement that bear the largest font size. For audio-visual advertisement, the risk warning statement should be in clear contrast in color with the background or backdrop of the advertisement. Where it appears in an independent screenshot, it should be displayed visually at the end of the advertisement for at least 3 seconds, with a clear readout for the same duration. Where the risk warning statement appears throughout the entire advertisement, it should be shown clearly at the bottom of the screen, with the height of each Chinese character of the statement be at least 1/15 of the screen, with the height of the capital letters of the English statement be at least 1/20 of the screen. It should also come with a clear readout in the same pace as the other contents of the advertisement. For internet advertisement, the first type is website banner, which links to another website. The risk warning statement should be displayed on the landing page in text in at least 50% of the font size and in the same font type and color as the other contents that bear the largest font size on the landing page. For advertisement with a static screen on the internet, the guidance for advertisement in print applies. Regarding the audiovisual advertisement on the internet, the guidance for audiovisual advertisement apply as well. There are also some points for you to pay attention to for licensing condition 8 and 9. The first one is that advertisement related to money lending business, including all kinds of publicity materials, shall comply with licensing conditions 8 and 9. And moneylenders should ensure to display the valid moneylender's license number in advertisement. Therefore, after granting the renewal of moneylender's license, you should update the moneylender's license number in all advertisement and the publicity materials. The advertisement must contain the moneylender's telephone hotline for handling complaints. Application hotline or inquiry hotline is not equivalent to complaint hotline. The name of the moneylender as specified in the license must be shown in the moneylending advertisement, but not only showing the business name of the moneylender. This is the requirement under Section 26 of the Moneylenders Ordinance. The moneylenders post on social media, including but not limited to the pictures, videos, or captions, may be regarded as one or more advertisements, depending on the actual situation. Moneylenders must ensure that such posts comply with the licensing conditions 8 and 9. Here we come to the licensing condition 10. The moneylender and his debt collectors shall not try to recover debts, whether directly or indirectly from anyone, for example, referees or borrowers, family members, or friends, unless such person is not indebted to him, and shall not harass anyone, shall not adopt unlawful or improper debt collection practices. On the other hand, the moneylenders shall ensure personal data collected are protected against unauthorized or accidental access, processing, erasure, or other use by the debt collectors, and shall comply with the Personal Data Privacy Ordinance, shall maintain and monitor proper systems and procedures for handling complaints and inquiries relating to the loans lent by him in the ordinary course of business and the debt collection activities arising therefrom, and shall keep updated and accurate records of the debt collection activities of his debt collectors during the terms of the license. Please note that the records should at least include the dates and methods of the debt collection activities. Please also note that whether the debt collector complies with the law and the relevant requirements under this condition in his debt collection activities is a factor for determination of whether the moneylender is a fit and proper person to carry on business as a moneylender. Moneylenders must exercise proper care and diligence to monitor the debt collection activities of their debt collectors. And debt collectors should not be given a free hand as to the debt recovery procedures. For licensing condition 11, the moneylender shall provide information relating to his moneylending business during the terms of the license, as may be required by the Registrar of Moneylenders or the Commissioner of Police within such time as specified. For example, the annual exercise for collection of financial information, thematic surveys, and quarterly return on personal loan, in which the Registrar of Moneylenders requires the moneylenders to participate. For licensing condition 12, the moneylender must establish and maintain proper system and procedures to ensure that the foreign parties shall be informed of and observe the licensing conditions and the provisions of the moneylenders ordinance. The parties include moneylenders and his partners, employers, employees, principals or agents, or person acting for him, and any appointed third parties. The system and procedures include the management and supervision, review of appointed third parties, personnel and training, and record keeping. Under licensing condition 13, where any referee is provided in respect of the loan application, the moneylender shall, before entering into any agreement for loan, ask the intending borrower to provide the written consent signed by the referees, confirming his agreement to act as referee in respect of the loan application, and attach the written consent to the loan agreement. If moneylender is informed or aware that the written consent was in fact not signed by the referee, the moneylender shall immediately cease to use the information of the referee. Please note that referee is the person who provides on a voluntary basis and upon request by the moneylender information about the intending borrower in respect of the loan application. For example, for identification purpose of the intending borrower before entering into the loan agreement. Please also note that Referee is not for debt collection or for contacting the borrower after the loan agreement has been entered into. Annex 5 of the Guidelines on Licensing Conditions is a sample form on written consent by referee for loan application. According to Licensing Condition 14, moneylender must comply with the Guideline on Anti-Money Laundering and Counter-Financing of Terrorism for licensed moneylender issued by the registrar as revised from time to time, and adopt a risk-based approach based on the institutional money laundering and terrorist financing risk assessment in the design and implementation of their anti-money laundering and counter-financing of terrorism policy, procedures, and controls on the following areas: compliance management arrangements, customer due diligence measures, ongoing monitoring of customers, suspicious transaction reporting, record keeping, employee screening procedure, ongoing employee training program, independent audit function, compliance with legislation on terrorist financing, financial sanctions, and financing of proliferation of weapons of mass destruction. The AML guideline can be downloaded from the company's registry website. And please pay attention to the following points regarding the licensing condition 14. The first one is that moneylenders should conduct its institutional MLTF risk assessment every 2 years and upon triggered events which are material to the moneylender's business and risk exposure. And moneylenders should assess the MLTF risk associated with a proposed business relationship with the intending borrower at the initial stage of the customer due diligence process, that is, conducting the customer risk assessment on the AML aspect. And moneylender should determine whether a customer and a beneficial owner of the customer is a politically exposed person before establishing a business relationship with the customer. And also, moneylender should maintain a database of name and particulars of terrorists and designated parties, which consolidates the various lists that have been made known to them. Alternatively, moneylenders may subscribe to such a database maintained by a third-party service provider and take appropriate measures to ensure the completeness and accuracy of the database, for example, conducting sample testing periodically. And also, the moneylender should implement an effective screening mechanism, which should include screening its customers and any beneficial owner of the customer against the current database at the establishment of the business relationship, and against all new and any updated destinations to the database as soon as practicable. Okay, here we come to the last licensing condition, licensing condition 15. Before entering into agreement for unsecured personal loan or before granting any significant increase in the amount of loan under an agreement for unsecured personal loan, the moneylender shall undertake an assessment of the intending borrowers or borrowers' ability to make repayments under the loan agreement affordably and have due regard to the outcome of the assessment in respect of affordability. In carrying out of the assessment, the moneylender shall consider the intending borrowers or borrowers' current income and expenditure, the ability to make repayments under the loan agreement as they fall due over the life of the loan agreement, without having to borrow to meet repayments, without the repayments having a significant adverse impact on the overall financial situation of the borrower. And the assessment must be reasonable. The moneylender must base the affordability assessment on sufficient information available to him at the time of conducting the assessment. The extent and scope of the assessment, the steps that the moneylender must take, and the evidence to be taken into account are dependent upon and proportionate to the individual circumstances of each case. The moneylender should adopt a common sense approach and decide what is appropriate and proportionate in the circumstances of a particular case. And there are some factors for consideration in the assessment. The total amount of principal and interest payable, duration of the terms for repayment of the loan, frequency and amount of the repayment, interest rate, purpose of obtaining the loan, employment or business of the intending borrower, current credit and financial information on the intending borrower, any other potential adverse consequences for the borrower or intending borrower arising under the loan agreement from a failure to make a repayment by the due date. The moneylender must also take reasonable steps to determine the amount or make a reasonable estimate of the current income and expenditure of the intending borrower. In doing so, moneylender can consider the salaries and savings and assets when considering the current income of the borrower. For expenditure, moneylender should consider the living expenses of the borrower and the amount of repayment of any outside debt and the amount of repayment under the current loan agreement, and whether there is any other foreseeable change of the borrower situation. And moneylenders must also keep written or video or audio records to show that he has complied with the requirements under the licensing condition 15. For licensing condition 15, there are also some points for you to pay special attention to. The first one, self-declaration of income and expenditure by the borrower or intending borrower is not an affordability assessment. Moneylenders must base the assessment on sufficient information available with evidence to show the assessment is carried out by the moneylender. For example, by signing and dating the written assessment. And moneylender should conduct the affordability assessment based on the actual circumstances of the intending borrower and keep relevant records. They should not assume every intending borrower or every category of borrowers has the same income and expenditure. For example, if the borrower is a university student, you cannot assume all university students. The current income is 5,000 and the expenditure is 2,000. You have to, based on the actual circumstances of each intending borrower, to determine the current income and expenditure. And assessment records must show the factors that the moneylender has considered, especially the special factors. The moneylender must also ensure the information shown in the assessment matches with the information provided by the intending borrower. For example, the information stated in the loan application forms and the income proof, etc. And moneylenders should also adopt a common sense approach and decide the reasonableness of the information provided by the intending borrower. Moneylender should require the intending borrower to provide relevant supporting documents if appropriate, and keep copies of the supporting documents. We have finished all 15 licensing conditions, but there is one more point I would like to mention. In addition to new loan agreements, the above-mentioned licensing conditions relating to loan agreement also apply to the extension or renewal of loan agreements. Therefore, when entering into any extension or renewal of loan agreements, moneylenders are also required to comply with the relevant licensing conditions. And the company's registry has issued various guidelines, including the guidelines on licensing conditions of moneylenders license, guideline on anti-money laundering and counter-financing of terrorism for licensed moneylender, guideline on fit and proper criteria for licensing of moneylenders. And the last one is the guideline on submission of business plan by applicant of a moneylender's license. All these 4 guidelines can be downloaded from the company's registry website. And this is the inquiry hotline and email address of the moneylender session. That's all of my sharing today. Thank you.